On the record, in the matter of the people of the city of Lansing versus Carol Vandemore, file number 23-00271. Vandemore, you can hear me?
Yes, ma'am.
Okay. Today is the date set for an arraignment on a probation violation. The allegations are that you committed the following technical probation violations. That you had a SoberLink positive test on October 14th of 0.052 and on November 1st of 0.039, and that per SoberLink, a failed retest following a positive blood alcohol content test on November 1st, 2023. And so you have the right to have a contested hearing as to these violations. If you're found to be in violation of your probation status, your probation can be revoked and you can be sentenced to a term of jail time, or your probation can be extended with a term of jail time, or you can have additional sanction or oversight imposed as part of your probationary status, okay?
Yes, ma'am.
Did you want to request an attorney to represent you?
No.
Excuse me?
Yes.
Okay.
Sorry.
Okay, so I'll note that you want to meet with the court-appointed counsel, and we do have Mr. Lee here today, and he'll get information for you to get that paperwork completed. We'll enter a plea of not guilty on your behalf. I'm going to set this for an in-person hearing, okay?
Yes, ma'am.
November 28th at 1:30.
November 28th at 1:30.
Okay.
Do you have any questions at this time?
No, ma'am.
Okay, Mr. Lee, can I put her in the room with you?
Yes, Your Honor.
Thank you. Tamia Russell?
Yes.
Okay. Okay, Mr. Smith, I think you're here with the matter for Tamia Russell.
That's correct, Your Honor.
Okay, let me find the file really quickly.
I ordered the cane put in.
Okay, I'll put you all in a private meeting room.
Okay,
I don't
Thank you, Your Honor.
understand why- No problem. I don't understand why my down to the bottom looks so different now.
Why do you supposed to do that when you get a call?
Mr. Smith, were you all set? Because it looks like Ms. Russell logged out.
Yeah, it's unfortunate. We did get into the breakout room. What brings us here today was failure to produce documents related to employment with Tamia. We got into the breakout room and she was having some technical difficulties. She said she couldn't hear me. Hopefully she's calling back in here.
Oh, there she goes.
But what brought us here today really had to do with Tamia's failure to produce documents that were responsive to your original subpoena. We had sent a reminder letter after that hearing. I believe it was in August. I don't know why she hasn't sent the documents, but that's what brings us here today, Your Honor.
Okay, Ms. Russell, can you hear us now?
Yes.
Okay, on the record in the matter of Lafque versus Tamia Russell, file number 22-01099 GC, counsel appearance for the record.
Plaintiff Lafque Tim Smith, P48259.
Okay, Ms. Russell, today was the date that was set for a motion to show cause, and the show cause issue was that you failed to produce documents that you were supposed to produce after being present in the court back on August 29th. Ms. Russell, is there something more important that you need to attend to?
Well, that was my mom talking to me, which is the reason why I'm here. It was her that got scammed. I was on the account. She was paying. So she was basically telling me to say something to you about her.
Okay, can you answer my last question then?
What was the last question?
That's the point. I'm talking to you and you're having a side conversation. And so it would not be appropriate to have a side conversation while I'm addressing you. And if your mom wants an opportunity to talk to you, then that needs to happen when we're not in the middle of me being on the record, okay?
Yes.
Okay. Why did you not produce the documents you were supposed to produce back in August?
I thought my mom was still making the payments from the last court date. Because she paid
Okay.
$200 that day. I thought she was still paying it.
Okay, that may be the case. Maybe she was, maybe she was not, but that has nothing to do with you having a subpoena to produce certain documentation, which is a court order for you to produce documents.
I
Why
didn't know.
why didn't
I
you?
didn't know it was a subpoena. I thought it was just through the other guy telling me to do that. I didn't know that you subpoenaed me to do that.
Yeah, that's why we subpoenaed you back here today. This is so that we can get this information resolved. So the court is ordering you to do these things, and the court is ordering you to appear. Do you recall what the documents were that you were supposed to produce?
Check stubs, and then also they had sent a thing to take my mom's taxes, so I kind of thought it was cleared up.
Well, you thought that the past due debt was resolved in full? Is that what you mean by cleared up?
Yes.
Oh.
Yes.
Mr. Smith, did you want to address the garnishment and whether or not that took care of the past due amount?
You bet, Your Honor. November 1st starts income tax garnishment season for the 2023 tax filing. These two defendants, the mother who she's talking to is the co-defendant. Income tax garnishments were filed against both. They recently received copies of those, but even if there is a refund owed to either that's intercepted, we're not going to see that till March, April of 2024. The balance today is currently $1,211.02. So the debt remains. There is a balance owed. There is an income tax garnishment in place, but there's no money that will be coming in for the next couple months easily, if any.
The balance, what's the balance again?
Balance today, $1,211.02.
Oh, okay. Do you understand that, Ms. Russell?
Yes.
Oh, okay.
Excuse me, Your Honor. My mom wants to know if she could talk to you.
Okay, can you put her on the screen, please?
Ooh-wee, I'm not looking good here. I don't care. I care. Yes, Your Honor.
Ma'am, what's your name? What is your name, ma'am?
I'm Bonnie Morris.
Okay, Ms. Morris.
Yes, I'm the person that I'm the person that got scammed. Okay, this is my bill. My niece was only on the account as a co-person because she just had moved back to Michigan after being in Ohio for 8 years, and she needed
who's your niece?
Samia Russell.
Oh, I thought you said it was your mom.
Okay, she's my niece, but she calls me mom. I raised her. Okay. She needed a checking account so she could cash her checks from her job, and all that. So I just added her to my account. Afterwards is when I done what I thought was a legitimate transaction, and it was not. And this is where we're at. This has not, ma'am, I've been trying to tell Mr. Smith for the longest that this has nothing to do with my niece at all. She's just a name on the account.
Okay, well, that's not how it works when we're dealing with financial transactions. If someone's name is on the account, you don't just, after there's a judgment, get to say, well, they're just a name on the account. The plaintiff does have the right to pursue both of them, and you probably defaulted in the underlying matter, which is how we got here. Nonetheless, she's been ordered to provide some documents. So, and until or unless she is removed somehow from having any liability under this judgment, she needs to comply with the court order. Okay.
Well, how will we do that?
I still got to turn in check stubs so they can take my money. Is what she's saying.
So what you're saying is she still has to turn check stubs in and get her check garnished, which is, it's not her situation.
Yeah, well, it's her situation according to the law because she's named as a defendant and she never appeared in this case and defended the case to get her name removed. You can't defend it once the matter has been, a judgment is entered. That's not how you, that's not when you appear. You appeared when you got served and you let them know, hey, this was not her debt, this was my debt.
Ma'am, we did. We've been doing that from the very beginning
The very beginning of what?
of when they first sent me papers. The accused lawyers first sent me papers. I have given them money. I don't know where I gave them $600 or $700 over months. A few months period. I paid them money on this.
Okay, can you put Miss Russell back on the screen, please? I have a proof of service, and I'm only going over this one time. This is not really germane to what we're here for today. But I have a proof of service in our court file that says that Miss Tamia Russell was served in person with the underlying lawsuit. That's summons and complaint. It gives at the bottom a time frame whereby you are to respond to the lawsuit. There was no response. So you had 21 days from receiving this summons and a copy of the complaint to file a written answer with the court and to serve a copy on the other party or take lawful action in the court. And you have 28 days if you were served by mail or outside of the state. We never received any filing from a Bonnie Russell or a Tamia Russell, and it says here Tamia Russell was served personally. And so in July 19, 2022, default judgment was entered against you. So you never appeared, Ms. Russell, to defend the lawsuit. You can't not now come and try to defend, and now that they're trying to pursue recovery, because the statute of limitation, if you talk over me, this could get ugly. That's one thing I didn't do to you all. You don't do it to me either, okay? And so you can't come now and try to attack the judgment now that he's trying to pursue recovery. There's a statute of limitation according to the court rules as to when and how you can attack the judgment and the validity of that. At this point, it's been well over a year and you never appeared in the case until now that they're trying to garnish their wages. So you need to provide that information under this court rule, and then Mr. Smith can work with you and or the other party if their client's willing to do so to resolve the balance to keep you from having any liability. But until this matter is resolved or your name is removed from the judgment, you're still liable under the law. Did you have something you want to say?
Yes, I didn't. Every time I got a paper, all I did was bring it to her. I never even read it because it wasn't me. So that was my fault. I never even read it because I felt like she was taking care of it.
Okay, that's unfortunate to hear, but unfortunately, when you're personally named in a lawsuit, you can't just take it to someone else to have them take care of it. Otherwise, you'll end up liable, such as this case. I'll put you back in the private meeting room with Mr. Smith so you can go over the documents that he wants and let him know when you can provide those documents. This is the last time we're going to issue a show cause on this. If those documents aren't provided, a bench warrant will issue. Mr. Smith, you're already in room 2. I'm going to put her back in room 2.
Thank you.
Okay, sounds good. On the record in the matter of Hamilton Road LTD versus Claude Miller, file number 23-01344LT, counsel appearance.
Good afternoon, Your Honor. Gene Turnwald on behalf of Hamilton Road Limited.
And Mr. Turnwald, I believe you are the only person present on this matter. This matter was scheduled today at 2 o'clock for a motion hearing. It's now 2:18. I requested the civil department to set this for a hearing because I think there were a couple of things that went on and I felt something might have been missed. There was a motion to reconsider, and then there was another motion, I believe, that was subsequently withdrawn. And I think I went back and realized that the motion to reconsider was still outstanding. And so, you filed a motion to inspect the premise. I believe that's the one that was withdrawn. Is that correct, Mr. Cornwall?
That's correct. The premises have been inspected and they're satisfactory.
Okay, and you wanted a motion to reconsider the issue as it relates to staying the property?
Yes,
And then,
Your
or the escrow amount, you were requesting $1,600 a month for escrow, is that correct?
The core issue is the motion staying the property. I believe it's our view that the case law and the statute is quite clear. If the losing party wants a proceeding stayed, they have to file with the trial court. In this matter, there was a quiet title action. The other party filed a quiet title action claiming they were still the owners of the subject property on Pattongill. That case was dismissed on August 10th by the Ingham County Circuit Court, the trial court. They didn't even show up for it. They, however, filed an appeal. And it's our position that to appeal that, which they can, but they have to apply for a stay with the Ingham County Circuit Court, staying any eviction proceeding and file a circuit court bond. This ruling in the district court, which incidentally is not even the same parties. The occupants of the premises, the Davises, are not party to the appellate court appeal at this time. They're not even parties. For the stay to apply to them in the district court, it hampers any ownership of the property, which has been awarded to Hamilton Road by the circuit court. Hamilton Road is not able to rent it out for any value they want. They're not able to list the property for sale. They're not able to rent to anybody they wish. And it's because of the district court stay. The circuit court has heard the merits of the quiet title action and it dismissed them. If they want to stay, if they want to post an appellate bond, which would be about $140,000 at this point, they need to apply to either the circuit court or the Court of Appeal under MCR 7.209.
Okay. Again, the court has heard your argument, and this argument is the same argument that you presented to the court at the previous hearing on this matter. The defense counsels failed to appear. I'm going to grant your requests primarily by default because they failed to appear. Can you provide the court with an order on this motion to lift the stay? And then as to your motion for reconsideration and an increase of the escrow amount to $1,600 per month. I think they said they were paying $1,000 a month. What is the how big is this property?
The property, according to Zillow, is 2,200 square feet, 4-bedroom, 3.5 bath property. Zillow claims the value at $280,000. I personally happen to be, in addition to a lawyer, a real estate broker in Michigan for approximately 12 years, 10 years, 11 years. And I have evaluated the property there on Pattongill. And I authored a letter in May on behalf of Hamilton Road, assessing the fair rental value at approximately $1,600. Zillow claims their fair rental value is approximately $2,500. The matter, however, has become moot. If this court is granting the lift to stay, I'm asking the writ to be issued within 10 days. The escrow amount will no longer matter, and we'll apply for the escrow funds depending upon any response, if any. It's our position the fair market rental value of the property is at least $1,600 per month.
2518 Pattengale, correct?
Yes.
Okay, I'll grant your motion also as it relates to the escrow, although you believe it's an issue, there is that large chance that there's going to be a subsequent motion from the defense counsel who's now failed to appear. And so to the extent that that happens and that ties this matter over for a motion to stop the eviction, you'll also have the escrow order amended as well, okay?
Thank you, Your Honor.
Thank you. And you can provide an order under the 7-day rule?
I will, right away.
Okay, thank you. You're all set.
Thank you.
You're welcome.
Excuse me, Judge.
Yes, ma'am.
It wouldn't let me leave the thingy. My phone was froze. So I don't know if Mr. Smith talked to you because it wouldn't let me like hit the button to leave the breakout
No, I
room.
haven't spoken to Mr. Smith since you all have been back,
Okay.
back on the record in the matter of LAFQ versus Smith. Did the parties resolve their matter in the private breakout room?
To some extent, we at least we have a game plan, Your Honor. 2 sets of documents within the next 30 days. First, the last 6 copies of the last 6 payrolls. Secondly, the last 6 months of monthly account statements from Chime, which is the bank that she uses and directly deposits her check into. I will again send her a reminder letter of exactly what to send. She thought 30 days was enough time to get that to me. What I will do if I don't have the documents within 30 days, I can simply file well, I don't know. I guess I'll defer to you, Your Honor, because you said if they're not produced, you're going to move to bench warrant.
That's correct.
If I don't have them within 30 days, should I simply submit a bench warrant, Your Honor?
What I could do is I could set it for a control date, and that way the parties will appear to let me know if it's been resolved or not. If that doesn't happen, then we can move forward.
That sounds good to me.
Does December 27th work?
It does, Your Honor. If I
Okay,
receive the
December
documents before that date, I'll call the court to cancel.
Very good. December 27th at 2 p.m. Do you have any
Thank you, Your Honor.
questions today, Ms. Russell?
No.
Okay, you're all set. Thank you both.
Thank you, Your Honor.
Let's see. Have we seen Nicholas Trevino? No. Or Matthew DeLine? No one. Okay, thank you. On the record in the matter of Lansing Automakers versus Nicholas Trevino, file number 13-02031 GC, counsel appearance.
For plaintiff LAFCU, Tim Smith, P48259.
Okay, today was the date set for a show cause. The matter was set for 2 o'clock. It's 2:28. No one's appeared on behalf of Nicholas Trevino, and this was for a show cause, so bench work can issue.
Thank you, Your Honor.
Past due judgment amount.
The past due judgment amount is a small amount, $823.89.
Okay, you can do a bond for the full amount.
Thank you, Your Honor. We'll prepare and submit.
Thank you. Off the record on that matter. On the record in the matter of Lafque versus Matthew Deline, file number 15-014224 GC, appearance on this file.
Plaintiff Lapku, Tim Smith, P48259.
Okay, today was the date that was set on this matter for a show cause. There was looked like the last hearing where the parties were all together was back in 2018. So it looks like it failed to appear on the October 13th bench warrant can issue.
Thank you, Your Honor.
What's the amount of the judgment?
Balance today, $24,108.07.
You can do a bond at 5%.
We will prepare that and submit. Thank you, Your Honor.
Thank you, you're all set. That's all I have for you, Mr. Smith. Okay. Next. Let's see here. I see Mr. Lum. Who was the lady that was just here? Did she leave with Mr. Dewar? Yeah, I saw Mr. Dewar.
was Mia Hayes.
Okay. I see Mr. Simon Zany, but I don't see Anthony Bryant. What's your name?
Natea Torre.
Okay, Natea Torre is correct. Okay, we're going to put you on mute until we're ready to call your case, Ms. Torre.
Okay.
Thank you. Okay, let's see here.
So I just asked if it was okay if I crocheted in here in the meantime.
Good thing, but let's see here. Mr. Drew is ready.
Yeah, the consent judgment was her.
Okay, do we have anybody online that's ready to go to? I see. No. Did Bruce Hicks appear?
I'm representing Mr. Hicks, Your Honor.
Oh, okay. And what about Brooke Church? Brooke Church is present.
Yes.
Okay.
Hi.
Did they meet currently? Okay, we're gonna put you all in a private meeting room.
Okay.
You know. We can put them in a room. Mr. Lum is here on that too. Okay, what about Anthony Pryor? No, Anthony Pryor. On the record in the matter of Anthony James Pryor versus Simon Zaney, file number 23-02133 GC. Mr. Zaney, I see you present via Zoom. You do not have an attorney today, correct?
No, ma'am.
Okay, let's see. Today was the date and the time that was set for pretrial on a general civil matter. Matter was set for 2:30. It's 2:47. I have not seen in the court or on the virtual courtroom a Anthony Pryor or a representative of Anthony Pryor. So the case will be dismissed for lack of progress. You're all set.
Thank you, Judge. Have a good holiday.
Same to you. On the record in the matter of Kyle and Chelsea Schaefer versus Mia Hayes and all other occupants, file number 23-02383 LT, council appearance.
Thank you, Honor. Sam Dewar here on behalf of the plaintiff.
Okay, and then you're Miss Mia Hayes.
Yes, sir.
Okay, so today was the date and the time that was set for hearing for non-payment of rent. I have here a consent order for judgment, and so you want to enter judgment by consent, ma'am?
Yes, sir.
Okay. Are agreeing, ma'am, that there's rent to retain possession in the amount of $3,801.54 plus court costs of $157.96 for a total amount due of $3,959.50, and that you will pay that in full or vacate the premise here at 1604 Coleman Ave, apartment 3, no later than December 4th, 2023. Is that accurate?
Yes, Your Honor.
I have that accurate as well.
You do, Your Honor. Thank you.
Okay, you sign this document, ma'am.
Yes, Your Honor.
We also have answer and consent for landlord tenant judgment. This document, did you read this?
Yes, Your Honor.
You understand the rights here?
Yes, Your Honor.
So you understand that you have the right to be represented by an attorney during these eviction proceedings?
Yes, ma'am.
Do you want to give up that right?
Yes.
You also have the right to proceed to a trial. You could have had a jury trial had you demanded one. Did you want to give up your right to jury trial?
Yes, Your Honor.
Anybody threatening you to get you to give up any of those rights?
No, Your Honor.
Okay, so you are voluntarily waiving them?
Yes, Your Honor.
Okay, I understand that if you don't vacate the property or pay that a total amount of $3,959.50 no later than the 4th, that a writ will be issued and they can execute that against you to forcibly remove your things from the property.
Yes, Your Honor.
Do you have any questions?
No, ma'am.
Okay, you have 3 business days from today's date. If once you leave here, you realize you did misunderstood the rights that was discussed in this document and you need to request to set this judgment set aside, you would come back to the court and file a motion for that purpose, okay?
Yes, Your Honor.
Do you have any questions?
No.
Any additional matters for the record?
Nothing from plaintiff, Your Honor.
Thank you, you're all set.
Thank you.
Have a wonderful holiday.
Same to you. That's all Mr. Dewar had today. Yeah. Did we see anybody from Mr. Booth's office? Mr. Datz, which matter are you here for?
Good afternoon, Your Honor. I'm here on the Woodside matter.
Okay. Versus Kamika Elam?
Yes.
Okay. Is anybody here from law firm? Nobody? I'm confused why there's no one here. Okay, on the record in the matter of South Washington Park versus Natalia Torrey, file number 23-02400 LT. Ms. Torrey, today was the date and the time that was set for a hearing for non-payment of rent. The matter was set for hearing at 2:30. It's currently 2:52, but no one has appeared on behalf of South Washington Park. Is that correct? No one is here for South Washington Park? Okay, so the case will be dismissed for their lack of progress. So you're all set for today, okay? You're muted, ma'am. Can you unmute?
Is everything good now then?
Well, the case is dismissed because no one's appeared, so it's good for now. They may file a motion to set aside or reinstate the case. If they do that, you'll get a notice of hearing in the mail, okay?
Okay.
Thank you, you're all set. You see Mr. Doward here? Oh, no, we got a dismissal on that one. Okay. Let's see, anybody here from on Akaniki? For Akaniki? Mr. Dunning's passed away, so I don't know who's taking over. Anybody here on behalf of Kelly Jimerson? Anybody here on behalf of Tyler Latchaw? Okay, case dismissed. Oh, wait, we have an email here. Okay, we're not gonna send an email. They just stuck it in here. They should have just let us know. Reset this. I don't know who's gonna take over for Mr. Diamonds. So we'll reset that now. Okay, sounds good. Kamika Elam is here. Did she meet with person from Piper already? Do you have a phone with you? Yeah. Do you have an attorney representing you at all? No. Okay, we're gonna put you on Zoom so you can meet with Mr. Datz and see if you all can resolve the case. If not, we'll proceed with your hearing, okay?
Let's see if you just want to have her take down my cell number, she can call me directly.
What's your cell phone number?
989-284-0301.
Okay, we'll get her in a private meeting room and she'll call you. Okay, anybody here for Elena Henderson?
That's me, Judge.
You're Elena Henderson?
No, I'm Attorney Fox's office. Judge.
Oh, okay. Anybody here for Elena Henderson though?
No, not that we know of. And we did not see anybody before we stepped in too, Judge.
I don't think there's anybody else in the hallway. Okay, on the record, in the matter of Capital Commons versus Elena Henderson and file number 23-02450 LTE, council appearance.
Good afternoon, Your Honor. Carrie Zanin, case 67390 on behalf of plaintiff.
Okay, today was the date and the time that was set for a hearing for non-payment of rent. The matter was scheduled for 2:45. It's 2:56, and no one has appeared on behalf of Elena Henderson virtually or present in the courtroom. Did you want a motion to dismiss?
This is my motion for default judgment.
Okay, motion to default, I'm sorry, motion to default judgment is granted. You have that with you.
Proposed judgment, I do. I'm showing that rent is due in the amount of $4,825, court costs of $175, for total rent retained of $5,000 for possession only, asking for a writ to issue on or after December 4th of 2023. And I will fill this other form out, Judge.
Thank you. Motion for default will enter and we'll sign and date that for today once we receive it. Let's see, any additional matters for the record?
No, Judge.
Okay, that's very good, thank you. We did it, we have a dismissal for Lindsay already.
We do, Judge, and if you need another copy, I brought one.
I think I signed it. I'm just crossing off on my docket. Let's see, Mr. Lum, you're back.
Yes, Your Honor.
Okay, I do see this church. On the record in the matter of Brooke Ashley Church versus Bruce Hicks and potential unlimited, file number 23-01873 GC. The council can have your appearance.
Good afternoon, Your Honor. Brian Lum on behalf of the defendants.
Okay, and then Ms. Church is present via Zoom without counsel, correct, ma'am?
Correct.
Okay, today was the date and the time that was set for a pre-trial. The parties did meet. Did you come to either a resolution or did you complete a joint pre-trial statement?
We did go through a pretrial statement, Your Honor. I just discussed it with Ms. Church over Zoom. I was going to complete it and send it to her for her approval.
Okay, very good. So, okay, so did you have any questions today, Ms. Church, about that joint pre-trial statement?
No, I do not.
Okay, we did get a copy of documents from you. I believe these must be your proposed exhibits and witness list. Is that correct, ma'am?
That is correct.
Okay, and then Mr. Lum, did you by any chance get a copy of this?
I did receive 2 emails with some pictures that were not attached, but they were included in the email.
Okay, very good. We'll keep this stack in the file should we need them as we proceed, and then we'll look forward to getting your filing for your joint pretrial statement. Unless you have any questions for us, Ms. Church, what will happen is once we get the signed joint pretrial statement, that will help us initiate your scheduling order. We'll send you an order with your next dates. So you'll get a date for the deadline of your discovery period if you all are going to be exchanging documents during discovery. And you'll get a date whereby you would need to file any motions if you wanted a motion for summary judgment to be considered by the court. And then you'll also get a date for your trial, okay?
Okay.
Do you have any questions?
I do not. Thank you.
Thank you. You're both all set on this matter.
All right. Have a good day. Thank you.
Thank you, Your Honor.
Thank you. That was this one. This is on the record in the matter of Woodside Meadows versus Lisa Eckert and Christopher Gaffney. File number 23-02486 LT. Council, may I have your appearance?
Mark Dates on behalf of Woodside.
Okay, and I see Lisa Eckert and Christopher Gaffney via Zoom, is that correct?
Yes,
Do you have an attorney representing you at all?
we do not.
Okay, I have here a judgment. It says that the parties want to enter into judgment by consent. Is that correct, Ms.
Yeah.
Eckert and Mr. Gaffney? Okay. And so you, Mr. Gaffney and Ms. Eckert are consenting that judgment should enter against you in the amount of rent to retain $5,562.45 plus court cost of $155 for a total amount due of $5,717.45. Is that accurate?
I know there was some issues where they were overcharging us. Like our lease says we are supposed to owe $860 a month, and they've been charging us $1075.
Okay, so you dispute the amount?
We know we owe. We're not disputing that. We just the amount should be different.
You know how we discussed that you were looking to vacate?
Yeah.
If I just took the number straight off and made it a straight up vacate to the 22nd, you would agree to that, correct?
Correct. Yep.
So if you want to dispute the numbers and they wanted to come after you, you could have that same defense down the road, correct? But you are looking to vacate by December 22nd. Would that be correct?
Yes. Yep.
Okay, what is their rent amount?
Our rent is $860.
That's what I see in my file attached to the complaint. Why were they charged something different on the judgment?
I don't know. When we first went through.
I'm asking the attorney actually at this point.
I don't know, Your Honor.
Okay, well, but if they're gonna be charged with, it says in the filings that your client filed with the court. You can't make up another number for the purposes of a judgment.
I understand.
Back in the private meeting room. Okay, and then Ms. Henderson appeared, you said?
Yeah, I got an email from the bond downstairs. She was parking.
Elena Henderson here? Interesting. Okay, I see. Let's see them, but you are back in the room. Okay, back on the record, in the matter, with Lisa Eckert and Christopher Gaffney, do we have a new amount?
We agreed to a case dismissal to, as long as we agreed to move out by the 22nd of December.
Yes, Your Honor, we agreed to a conditional dismissal. We're gonna turn this over to a straight up vacate and take the numbers off of it, and they've just agreed by the vacate the 22nd.
Did I actually do that? I was gonna say. Okay. Conditional dismissal, you said, Mr. Datz?
Yes, Your Honor.
Okay, so there's a dismissal today upon the condition that they vacate when?
By December 22nd.
That's how you want to proceed, Ms. Eckert?
Yes.
What about you, Mr. Gaffney?
Yes.
Okay, you have the right to be represented by an attorney at your eviction proceeding. Did you understand that?
Yes.
Yep.
Okay, and did you want to waive your right to counsel to move forward with a conditional dismissal?
Yes.
Yes.
Okay, you also have the right to proceed to trial, and you have the right to a jury trial. Did you understand those rights as well?
Yes.
Yes, ma'am.
You want to waive your right to jury trial so that you can move forward with having the case dismissed upon the condition that you vacate no later than December 22nd.
Yes, ma'am.
Okay, anybody threatening you to get you to waive those rights?
No.
No. No, ma'am.
How about has there been any promises made to you to get you to waive those rights?
No.
No, ma'am.
You have 3 business days from today. If once you leave here, you realize you did misunderstand those rights, you can return to the court and request this case be reinstated and explain to the court how you misunderstood your rights. Also, you should understand that with the conditional dismissal, partial performance will not satisfy it. So if you're agreeing to vacate by the 22nd, that means you're removing all of your personal items and your trash and other belongings out of the premise, and you're turning over the key in broom swept condition on or before that date. Do you understand that?
Yes.
Yes, ma'am.
Do you have any questions at this time?
No,
No
ma'am.
questions.
Okay, any additional matters for the record, counsel?
Yes, Your Honor. Ms. Eckhart and Mr. Gaffney, you give me permission to sign the conditional dismissal on your behalf and submit to the court with you on the email?
Yes.
Yes.
Thank you.
Thank you. You're all set.
Thank you.
Thank you so much. Have a great day.
You too.
Same to you. On the record in the matter of Woodside Meadows versus Carmika Elam, file number 23-02487. Counsel, can I have your appearance?
Correct dates on behalf of Woodside.
Okay, and then I have Ms. Elam present in the courtroom. Ms. Elam, you can come up to the table, please. Today's the date and the time that's set for a hearing on a eviction for non-payment of rent, and you did meet with Mr. Datz on behalf of the plaintiff. How are we proceeding, Mr. Datz?
Yes, Your Honor, we agreed to a conditional dismissal with rent owing through today's date of $3,720, court cost of $155. We agreed to add on December's rent of $1,260, $1,260, for a total of $5,135. And we're giving Ms. Elam until the 22nd of December to get that balance caught up or vacate the property.
So Ms. Elam, is that accurate? Yes. Okay, and so do you understand that you have the right to be represented by an attorney at today's proceeding? Yes. Are you giving up your right to be represented today? Yes. You also have the right to proceed to trial. You had the right to a jury trial. Do you want to waive your right to trial in order to move forward with the conditional dismissal? Yes. Okay, so you're agreeing to pay the past due amount of rent, $3,720 plus court costs of $155 plus your December rent for a grand total of $5,135, or vacate by December 22nd? Yes. Okay. Is anybody threatening you to get you to waive those rights and proceed with this conditional dismissal? No. Any promises to you, ma'am?
No.
Okay, you have 3 business days from today. If once you leave here, you realize you did misunderstand those rights, you can return to the court and request to have this agreement set aside. We will put it on for a hearing. You'll explain how you misunderstood your rights, okay? Do you give Mr. Dapp permission to sign a conditional dismissal on your behalf?
Yes.
Any additional matters for the record?
Nothing further, Your Honor. Thank you.
You're all set, ma'am. Thank you.
Thank you.
I believe that's my last matter. You have a wonderful weekend and wonderful Thanksgiving, Your Honor.
Same to you, sir. I need to file for that. That's wild. Okay, let's see. Where are we parking our car? That is the question.
I love you. So very grateful.
I just want to know where we're
I was
parking.
just said to I just said to my client, I'm like, you should bring me lunch.
It's downtown Lansing. It's not. I bet you there's parking right there. Okay, sounds good. We're done with this.
Here's my default. Thank you.
If she comes, she can go downstairs and file a motion.
Thank you.
Thank you.
Yeah, the default. I just have one more case, Judge, that's actually scheduled. You're giving me a, so next time I'm prepared. I appreciate you.
Nobody on Zoom. They need a major one?
Yes, Judge.
Okay. So she's parking her car too. The property's not vacant?
It is not vacant, Judge. I hear my client is here.
Okay.
And I double checked it, but that was, I saw that the notes from the last hearing.
Okay, sounds good. Okay, she failed to appear. You can just submit default on that one.
Thank you. No.
Is anybody in the hallway? Somebody's talking to somebody. Let's see who that is. Oh, for